Welcome to LawCram. Let's discuss C.F.R. Subpart 9.5, Organizational and Consultant Conflicts of Interest. The purpose of C.F.R. Subpart 9.5 is to prevent the existence of conflicting roles that might bias a contractor's judgment and to prevent unfair competitive advantage. For example, an unfair competitive advantage exists where a contractor competing for award of any federal contract possesses proprietary information that was obtained from a government official without proper authorization, or source selection information that is relevant to the contract but is not available to all competitors. And such information would assist the contractor in obtaining the contract. Organizational conflicts of interest are more likely to occur in contracts involving management support services, consultant or other professional services, contractor performance of or assistance in technical evaluations, or systems engineering and technical direction work performed by a contractor that does not have overall contractual responsibility for development or production. In the case of Filtration Development Co. versus United States, the United States Court of Federal Claims found that the contracting officer's determination that a significant organizational conflict of interest did not exist was contradicted by the record. The contracting officer did properly contact other government personnel to apprise them of the situation. Those personnel informed the contracting officer that they recognized the potential for a conflict of interest. Their conclusion was buttressed by the fact that the awardee submitted at least 2 proposed mitigation plans. Therefore, the court determined that it was safe to conclude that all of the parties involved recognized a significant conflict of interest. However, the contracting officer exceeded her authority by concluding that the appropriate safeguards were in place to eliminate the conflict. According to the Federal Acquisition Regulation, that is not a decision that the contracting officer is empowered to make. The authority to approve, modify, or reject a recommended course of action for avoiding, neutralizing, or mitigating a conflict rests with the chief of the contracting officer. Accordingly, in that case, the contracting officer failed to abide by the procedure set forth in the C.F.R.